All right, well then, in paragraph 38, the complaint alleges that Oklahoma statute, the same thing that we've been talking about, is unconstitutional, both on its face and as applied to plaintiffs, because it compels plaintiffs and all similar class members to engage in speech and communicate the government's message in violation of the First Amendment. Now, do you believe that this statute to be facially unconstitutional, Larry?
No, I do not believe it to be facially unconstitutional at all. Remember that for something to be deemed facially unconstitutional, there must be no set of circumstances in which it could be done. So we can eliminate this as being facially unconstitutional just by understanding the very case that went to the Supreme Court called Broderick versus Oklahoma. I'm pretty sure that originated from Oklahoma, where they.
Why do you say that? What makes you say
that? I'm fairly certain that it did, but I can't remember all the details of the case. But I think there are a number of ways to mark driver's licenses that would pass constitutional muster. We mark driver's licenses all the time. We mark underage driver's licenses. We mark those with DWI convictions while they're required to have an interlock license here in our state. We mark the licenses of those who must wear corrective lenses. So marking driver's license is perfectly fine, but this marking here is the problem. So at best, this is going to be as applied. They're not going to issue an order and say that there's no set of circumstances where PFR licenses can ever be marked, because you can mark it very discreetly. Rather than having that big orange sexual offender on the license, you could have it in a code that only law enforcement would be able to access. So I think they lose on that one.
Well, of course, Mr. Doom and Gloom is certainly present tonight, and we need to move along.